We're going to talk about purchasing and disposing of property today, and the buying and selling of municipal property can encompass many things. So we're going to take a look at each of those different aspects. Property can include real and personal property, so we'll start our discussion with real property. Then we'll discuss what you need to do in order to dispose of real property and the numerous requirements that exist in that area. Next, we're going to go over Indiana Code 5-22, which covers the purchase of personal property. And we'll wrap things up with what you need to do if you ever need to dispose of personal property. And in our discussions today, you're going to hear a lot of Indiana codes and different citations and some quotes from the statutes. You'll be sure to want to discuss those with your attorney from a legal aspect. We're going to address today what we look at those from an audit perspective and what we'll need to see, what kind of documentation we're going to want to look at during an audit. So let's get started with what you need to do in order to purchase real property. And when we're using the term real property, we're basically talking about land or land with building or structures on it. The opportunity to purchase real property may not present itself very often for a city or town, but when it does, Indiana Code 36-1-10.5, titled Purchase of Land or Structures, is the governing authority. This chapter applies to all political subdivisions, but there are several exclusions in 36-1-10.5-1. For example, this chapter does not apply to real property having a total price, including land and structures, of less than $25,000. It also doesn't apply to airport land or structures under Indiana Code 8-22. Land or structures acquired for a road or street right-of-way for a federal aid project funded in part under 23 USC 101. Or it doesn't apply to purchases for redevelopment commissions or redevelopment authorities. There's some others that are mentioned in 36-1-10.5, but these are the main ones you might encounter, but obviously you're going to want to refer to that statute to see if there are any of the other exclusions that might pertain to your city or town. The term purchasing agent is one you should have heard before. Each unit should have a purchasing agent. And as used in 36-1-10.5, purchasing agent is the board or the officer of a city or town with the power to purchase land or structures. The 36-1-10.5-5 lists what needs to occur before land or structures can be purchased. First, the council shall pass an ordinance indicating their interest in purchasing specific land or a structure. Next, the purchasing agent shall appoint 2 appraisers to appraise the fair market value of the land or structures. These appraisers must be professionally engaged in making appraisals or trained as an appraiser and licensed as a broker under Indiana Code 25-34.1. The appraiser shall return their separate appraisals within 30 days after the date of their appointment. And although it's not listed on the slide, the statute requires that the purchasing agent keep the appraisals on file for 5 years. And finally, the purchasing agent gives both appraisals to the fiscal body. Then we get to the all-important purchase price. Section 6 of 36-1-10.5 simply states that the purchasing agent may not purchase any land or structure for a price that's greater than the average of those 2 appraisals. So if appraiser number 1 came back with a report that said the fair market value of the land or the structure you were looking at was $60,000, And appraiser number 2's report showed that the fair market value was $90,000. Then the purchase price could not exceed the average of $60,000 and $90,000, which would be $75,000. So if you really, really wanted this property and you just had to have it, and you went out and you bought it, but you had to pay more than $75,000 for it, that would be something during an audit that would probably generate an exception on our part that could result in a comment in your written report or management letter. Now that's a pretty simplistic example, and what you run into might be much more technical or detailed. Just make sure you have good documentation of the appraiser's values and how that average purchase price was arrived at. We have had the question before about if you can have more than 2 appraisers. And the position we've taken is 36.1 10.5-5 section 2 states that the purchasing agent shall appoint 2 appraisers. So it doesn't say at least 2 or more than 2 or more, it just says 2. So our position is you just have the 2 appraisers. So what are you gonna need when our examiners come in, they're auditing, and they start asking questions? We're gonna start with needing the resolution of the fiscal body indicating the specific land or structure that they're interested in buying. We're also going to want to see the documentation of the appraisers that were appointed and probably their credentials. So you might want to keep all that information maybe in a separate file, or a lot of you keep things like an audit file for us that you can just hand to the examiners or upload now as we're doing remote audits for the examiners to look at. We're also going to need those appraisals so that we can see what the appraised value was and how the appraisers came to that. And the documentation of the actual purchase price, including, as I mentioned in the previous slide, how the average was ascertained and whether you paid that average or less than or more than. So in conclusion, as to buying real property, the key is the appraisals from 2 qualified appraisers. It's going to set the stage for determining the average price that can't be exceeded in actually purchasing the property. So during an audit, I doubt we're going to dive too much into the qualifications of each appraiser, but their qualifications are important. They should be documented. And if you've got any questions related to an appraiser's qualifications, you want to address those to your attorney.
But now we're going to switch gears and we'll talk about disposing of real property. The main goal of this is to make you aware of what the various requirements are and the information that we need for audit. The process of disposing of real property is a function of counsel as a disposing agent. One of the biggest takeaways is going to be to make sure that the city and town attorney is consulted in the disposing of real property, because as you'll see that there are a lot of rules when it comes to disposing of real property. There's a lot of exceptions and there's a lot of definitions. So that just makes it complicated in and of itself. Now the primary statute is Indiana Code 36-111, and it does apply to all political subdivisions. Certain transactions are exempted from those requirements, and those are found in subsection 1B. There are 24 of those, so there are a lot of exceptions, and we'll talk about some of them today. For the purposes of this statute, property means all fixtures and real property to be included in a disposal, and it does not include personal property unless it's noted in that statute. And that's a little bit confusing because the title of the section 36-111 is a disposal of real and personal property, but there's very little personal property discussed in this section. And then the disposing agent would be the city or town council. Now also in this section, there are a lot of definitions. You need to know what the definitions are before you can understand the statutes. So we just wanted to make sure that we reference those here for you so that you can have them at another time. And as you can see, because of all the exceptions and all the definitions, it is, of course, important to talk to your attorney. There are certain persons that you can never sell property to, and those are defined in section 16 as ineligible persons. And those are ones who owe delinquent taxes or special assessments or penalties or interest or other costs, or a person who is an agent of them. So since it's mentioned so many times in 36.111, I thought I would just get that out of the way now so that you would know who an ineligible person is. Another thing to get out of the way now, there are a lot of notice requirements in the statute for advertising the sale of real property. And these are the statutes that we believe are applicable to that. For those of you who knew Charlie Pride, this information was handed down from him, so we're handing it over to you. But keep in mind that this is just our audit position. Please always consult the city or town attorney for all public notice requirements. It's a very serious requirement, and you want to make sure you do that correctly so that your city or town avoids any legal issues with the sale of property. Now, the process starts out with an approval process. The executive will designate a board to evaluate this sale of property, and they will give public notice under 531, which are the statutes that were on the previous slide. That board will also hold a public hearing, and as a result of that public hearing, they'll make a recommendation to the executive. The executive cannot make a recommendation on the sale of or disposal of real property without that recommendation. Then the executive can approve that, and then there are certain cases also where the fiscal body will need to approve that. The fiscal body of a unit must approve every sale of real property having an appraised value of $50,000 or more. The fiscal body can adopt an ordinance to increase that threshold to an amount greater than $50,000. So if they do that, you'll want to make sure that that ordinance is handy or copied for your audit file in relationship to a sale. They also have to approve every lease of real property where there's the total annual rental payments will be $25,000 or more, and every transfer of real property that was originally gifted to the city or town. Now, as usual, there are some exceptions to this, and those are in section 3.2 based on population parameters. So after the approval process, there's an appraisal process. And again, 2 appraisers are required in this statute. They do have to be licensed, or they can be employees familiar with the value of the property. And based on those appraisals, the disposing agent will make a determination of the minimum bid and the disposing agent's knowledge of that property. So this determination should be one thing that's documented in the audit file. We had the approval process, and we had an appraisal process. Now we have an advertising process, right? And the public notice is in accordance with 5312E, which was referenced on one of the previous slides. And there is a certain amount of information that has to go in that public notice. You have to discuss the minimum bid and any other terms and conditions. You have to discuss the date that bids will be received and the duration of the sale. And then again, there's those provisions regarding an ineligible person. And then there are usually provisions related to bids submitted by a trust that have to have certain pieces of information. There is a time of inspection and evaluation of those bids. The bids are open to the public, and one bidder can raise another bidder's bid. And that raise takes effect after the board's given proper notice to the bidders. And then finally, there's an award process or a rejection of bids. The award would be to the highest and best bidder, but the disposing agent, council does have the right to reject all bids. And if they do that, then there needs to be a written determination to reject the bids, and there should be an explanation along with that determination. So those were believe it or not, those were the general procedures in 36.111.4. There's an approval process and an appraisal process, an advertising process, and an award process. The rest of the time that we have are devoted to kind of exceptions or alternatives to these general procedures. And one alternative, or a couple of alternatives that the disposing agent has, is they can engage a broker or an auctioneer, or they can conduct the sale electronically. The engagement of a broker or an auctioneer does involve a determination by the council that it is in the exercise of good business judgment to hire that person. The disposing agent can hire one of the appraisers as the broker or auctioneer. And then the compensation paid to a broker or auctioneer can be paid out of the gross proceeds of the sale. Now, we do get a fair amount of questions on what that means, compensation of the auctioneer or broker out of the gross proceeds of the sale. And the proper procedure for that would be to go ahead and receipt in the gross proceeds to your fund, and then the amount to be paid to the broker or auctioneer would be paid through the claims process. The council can also hire an auctioneer. That person has to be licensed as well. The auction can be conducted at the beginning of the sale as advertised, or it can be conducted after the sale has begun. And there are certain notice requirements. The council would have to give each bidder who has submitted a bid notice of the time and place of the auction if it begins in the middle of the sale. FISC council can also hire a broker to sell real property rather than using the bid process if they, again, have a determination to hire the broker, and they make public notice of that under 531. Now, one of the provisions on this is that the property has to be up for bid for at least 60 days before the broker is hired, and either no bids were received or the disposing agent has rejected all the bids that were received. So those two conditions have to be present before a broker can be hired. On electronic sale, a disposing agent can conduct a public auction by electronic means and receive electronic payments. There should be some internal controls and policies established over that process. And then as far as your public notice is concerned, that should include a statement that the sale will be conducted electronically. And we do have a provision in our manual that says that the proceeds generated by the sale of property should be receipted into the fund which originally purchased the property unless otherwise provided by statute. So that is the general rule as to where to record those funds that have been received. Okay, there are provisions for leaseback in the statute. There is a little confusion between 36.110, where a unit would acquire property by lease, and the provisions that are listed here, which allows the fiscal body to dispose of the property by selling it and then leasing it back. So if you have that particular situation, there does have to be publication of that with these certain requirements here. The bids are open to public inspection, and then the disposing agent would have to sell that to the highest and the best bidder. Okay, there's a lot of different groups of special provisions that we're going to be talking about briefly. You'll notice that the slides have a lot of information on them, and that was done on purpose We wanted you to have this as a reference. If you have a particular situation, you could go to that slide and find the statutory reference. You should always read the statutory reference, of course, instead of the slide, but we did want to put as much information on there as possible for you. So this is the next section that we're going to be talking about. Okay, if you have a property that was not acquired by eminent domain and the purpose of disposal is to promote economic development or facilitate compatible land use planning, then you can follow the provisions in this section. There are still 2 appraisals that are required, and you may sell or transfer that property for the average of those 2 appraisals. There is a public notice statement requiring the amount that will be accepted. And then, of course, council can reject all bids, but if they do so, they have to make a written determination for that. The legislature did put a section in for public utilities that a sale or transfer where there's a public easement or right-of-way does not affect the public utilities use of that land, in case you ever need that statute. Okay, you might have a piece of property that's assessed at less than $15,000, or it's a part of a public right-of-way. And if you do, then Section 5 is going to apply to that. Council can increase that threshold above the $15,000 by ordinance. I'm not sure that's on the original slides that I had, but that is the case, so I wanted to add that in there. Here's another determination that must be documented. And to use this section, the disposing agent or the fiscal body has to determine the highest and best use of the tract is to an abutting landowner, or the cost to maintain the tract equal or exceeds the estimated fair market value, or that it's economically unjustifiable to sell under the requirements of 36-111-4, which was that approval, appraisal, advertising, and awarding process that we went through in the beginning. So if that is the case, then there are certain procedures in Section 5. There does have to be public notice. Now there are 2 parts to this public notice, and I did not make that clear on the slides. The first part is a public notice under 531 that we talked about at the very beginning. And the second part of the notice is to abutting landowners by certified mail. There is an appraisal process that's required unless the value of the land is less than $6,000, and then that appraisal is not required. And then there is the offer to purchase portion of it. And if an abutting landowner makes an offer, then the fiscal body council can negotiate the sale with that person. If more than one abutting landowner makes an offer, then there is certain rules for that. Or if no abutting landowner makes an offer, then there are certain rules for the fiscal body as well. Property acquired by tax default also has its own provisions. If you've received property by tax deed from the county, you can transfer that without consideration or for nominal consideration to an abutting landowner. And those terms, abutting landowner and real property acquired by tax default, are defined in the statute in this section. So if you're going to use this section, then there's a notice by certified mail to abutting landowners with certain pieces of information that are listed there. And then there's a negotiation and sale not earlier than 14 days from the date of notice. And there are different rules if there's just one eligible abutting landowner or if there's more than one. Okay, this next section, again, is more special provisions. Again, wanted you to have the citations for these, and we'll go through these as well. Sale or transfer to a fire department can be without consideration or for nominal consideration. and it's for items for construction of a fire station or other purposes related to firefighting. And fire department here refers to a volunteer fire department, a fire protection district, or a fire protection territory. And this one applies to real and personal property. It's one of the few that actually apply to personal property. Okay, there's also disposing of real property, exchanging with a person other than a governmental body. And that is possible under this section. Exchange can be made with a person that's not a governmental entity and that is an eligible person. The advertising that was required in those general provisions of Section 4 are required. And property conveyed should be considered partial or full payment for property the disposing agent receives under this section. You can exchange real property with another governmental entity. That should be, each unit should have substantially identical resolutions stating the agreed terms and conditions. And then that transfer can be made for any amount of real property or cash or personal property as agreed by the entities. Charlie Pride used to tell us that something has to be exchanged, but we make no determination on how much. It could be a nominal amount. There's also an exchange of property as part of the purchase price of new property. Whenever disposing agent purchases new property with the condition that property of a similar nature be traded in or exchanged as a part of that purchase, then that may be done without advertising. And there's another section here on gifts of tracts of land and reconveying that to the grantor, or a gift of tract by not-for-profit and reconveying that, or just general reconveyance procedures. I have these slides here for you to have as future reference, but we're not going to go over those today, just in the interest of time. Instead, we're going to talk about, spend more time on leasing of property. There are 3 sections on regarding leasing of property, and 36.111.10 would be the general procedures. And then there's a specific situation where you can lease a parkway strip, a sidewalk, tree row, or verge. And then there's also some alternative procedures for the leasing of property. So on these general provisions, the disposing agent does need to make a determination that it's in the best interest of the unit to lease property rather than dispose of it or transfer it or exchange it. There has to be 2 appraisals determining the fair rental value. The bidding process is the same as those general procedures we talked about at the beginning under 36.111.4. And then the award should be made to the highest and best bidder, or again, all bids can be rejected, and if they are, then the disposing agent would have to state why they were all rejected. And then there are several terms and conditions that can be considered as a part of the leasing contracts. You know, it may contain an option to renew or an option to purchase. It may provide that rental payments apply to a purchase price. And it may not be leased for more than 3 years unless approved by the fiscal body. Now I have that underlined there because I don't think it was on my original slides, but it may be leased for more than 3 years if it's specifically approved. And then rental at an amount less than 90% of the average of 2 appraisals does require additional notice. Okay, this particular statute was new in 2020 through Public Law 65/2020. And it has to do with the disposing of real property that's owned by a political subdivision that extends from the curb or the edge of a public street or roadway to the front of commercial property owned by a person. The term includes a parkway strip, a sidewalk, a tree row, or a verge. A political subdivision may, by ordinance or resolution, authorize the lease of property that the political subdivision owns to the owner or property manager of commercial property that abuts or fronts the property if the requirements in 36-111-10.5 are met. The lease can be upon agreed terms and subject to section 10.5, and that can be done without competitive bidding. Now I have the requirements here of 36-111-10.5D, and you can read through those at some other time, but what I wanted to call your attention to is that this has to be authorized by ordinance or resolution approved by at least 2/3 vote of the members of the fiscal body. So that's different than a lot of other votes that are taken. It requires that 2/3 vote. Okay, the statute also offers some other alternative procedures for leasing, and that would be through a request for proposals process. And the disposing agent, again, has to make a written determination, including reasons that 36-111-10, that's the general one, is not feasible, and they must go through a alternative procedure for request for proposals. And then the executive has to grant authorization in this case. So the requests for proposals are required to contain certain pieces of information that are listed here for your future reference. There does have to be notice given, again, in accordance with 531. And the disposing agent must make a determination what the most appropriate response would be to the request for proposals, and then follow through with that with the disposition of the property in accordance with that response. So that is also available in the leasing category. And I told you there were a lot of exceptions. What we talked about before were the general provisions, and then there were provisions that were specific to certain types of pieces of property. And we also have some exceptions that we'll go through that were some of the 24 that were listed in section 1B. And one of those is redevelopment property. A redevelopment commission has its own rules, and they can hold, use, and sell, exchange, lease, rent, or otherwise dispose of property that they have acquired on terms and conditions that the commission considers best for the unit and its inhabitants. That's their general power. There are several references to the sale of property in the redevelopment statutes, and we have those listed here for you. And again, that just depends on the certain circumstances. I mean, they will have, a sale to an abutting landowner maybe, or there's information if an urban enterprise association or community development corporation is involved. There's just a lot of different scenarios for redevelopment property that we have listed here for you, should you need those. There's also several other exceptions. If it involves the sale of utility property, you will want to go to Indiana Code 81.52. If it is property acquired by foreclosure or conveyance, there's a separate statute for that. Disposal of property under a public-private agreement arrangement is in 523. And then at the airport, they have their own rules as well in 822-8. So you want to take a look at all of those depending on who is selling the property or under what agreement. So kind of summarize all of that, as I said in the beginning, there are a lot of rules, there's a lot of exceptions when it comes to the disposal of real property. So we always recommend that a city or town obtain the written legal advice of the city or town attorney when disposing of real property. For audit purposes, all those determinations that we talked about should be in writing and part of your audit file. Also, compliance with the statutory requirements should be documented in your audit file. You should have copies and agreements or contracts available for audit. That's underlined because it was not in my original slides. And the property disposal should be recorded as a reduction on the capital asset ledger at the historical cost value. And that you would also need to add to your slides because I did not have that originally. And that's all I have on the disposal of real property. I will turn it over to Todd to continue on with personal property.
So let's change gears a little bit and talk about purchasing and disposals not involving real property. But first, we love to give you all that statutory background, so let me do that. Indiana Code 5-22 is the governing title and article for purchasing. 522.1.1 provides this article applies to expenditures of public funds by a governmental body, while 522.3.3 states that a city or town may adopt written policies and rules to regulate the process that supplement this article, and they're not inconsistent with the article. And so I underlined written policies. You've heard us talk about written policies all the time. So your purchasing agency needs to establish some written policies on how you're going to handle certain purchases. We'll talk about small purchases in a little bit and following your locally adopted policies and how we audit to that. Indiana Code 522.3.4 is one you might want to review a little more in depth. It provides that when notice is required by mail under 522, the material can be sent electronically as stated in locally adopted governmental body rules, written policies of the purchasing agency, or a solicitation. So it doesn't only mean post office, United States Post Office mail, it can be emailed. In our discussion earlier about real property, we discussed the definition in 36.1.10.5 of a purchasing agent. In 522.2.25 and 26, which aren't shown on the slide, there's a similar definition provided, and it says a purchasing agency is a governmental body authorized to enter into contracts by Article 22 or rules adopted under Article 22 or another law. A purchasing agent is an individual or individuals authorized by the purchasing agency to act on their behalf. The statutes in this slide provide that the individuals designated by the agency are the purchasing agents for the governmental body, and a purchasing agency can have more than one agent. So that's a lot of legal mumbo jumbo. You probably want to know how is this going to affect your city or town and your day-to-day routine. So basically, when you're doing these types of purchases, you're looking at three categories. Those where the purchase price is greater than $150,000. Those where the purchase price is at least $50,000, but not more than $150,000. And you can find that in IC 522.8.3. Or those purchases that are less than $50,000. And those are covered in 522.8.2. Of course, there are always some exceptions to the rules, like municipally owned utilities are exempt from Indiana Code 5-22. And there are some other special purchasing methods that we'll talk about in a few minutes. If the item to be purchased is estimated or is going to cost over $150,000, then you have to obtain competitive bids. IC 522.7.2 provides what the invitation must include, which is a purchase description, contractual terms, bid evaluation criteria. So 522.7.3 requires the criteria to be objectively measurable. It also has to include the time and location where the bids are going to be opened. A statement whether the bid must be accompanied by a certified check or other evidence of fiscal responsibility that may be imposed. and the conditions under which bids can be rejected or canceled. 522.75 provides for the notice that needs to be given, which is required by Indiana Code 5-3-1. And in 5312E, the requirement is the notice needs to be published 2 times, at least 1 week apart, with the second one at least 7 days before the date the bids will be received. So speaking of receiving bids, here are 4 statutes that are related to that. In Section 6, bids must be opened in a public meeting at the time and place designated in the invitation. In Section 7, they must be accepted without alteration and evaluated based on the requirements in the invitation. In Section 8, the contract must be awarded by written notice to the lowest responsible and responsive bidder. Now, we get a lot of questions on if contracts can be awarded to someone other than the lowest bidder. And we wanted to point out the statute states the lowest responsible and responsive bidder. So the lowest bid may not necessarily be the lowest responsible and responsive bidder. So for an audit purposes, if you don't take the lowest bidder, we're going to look for documentation or evidence as to why not. And that documentation is going to be the key in determining compliance with this statute. But again, that's our audit position. So if you have any concerns about not taking the lowest bidder, obviously consult with your attorney, try to get something in writing from the attorney that accepting the lowest bidder or not accepting the lowest bidder is going to be something that you can do and keep that in your audit files. And then in Section 9, the purchasing agent must keep the submitted bid and maintain a record of the names of each bidder and the amount of each bid, and all of those are open for public inspection. Some other considerations that are in 522.18. Section 1, you can give additional notice if it's determined it will increase competition, but the latest or the last notice still has to be at least 7 days prior to the receiving of the bid. So if you want to advertise all the time, you can do that. Just that last one has to still be a week before you're going to receive the bids. In Section 2, if it's determined it's in the best interest of your city or town, a solicitation can be canceled or all offers can be rejected. And the reason for doing so, you want to document that and again, keep that in your files for us to look at during an audit. And then in Section 3, the governmental body can make a written determination to delay the opening if it's in the best interest of the city or town. Any delay has to be announced at the originally scheduled opening day, time, and place. Next is what the code refers to as small purchases, and those are found in 522.8. For small purchases where the cost is between $50,000 and $100,000, quotes from 3 persons or vendors known to deal in the equipment or supplies being purchased should be invited. These should be obtained by mailing an invitation to quote at least 7 days prior to the deadline for receiving the quotes. And recall that I mentioned earlier that mail includes email, so you can email your 3 vendors. If the purchasing agent receives a satisfactory quote, the agent shall award a contract to the lowest and responsive offerer. So again, as with the bids, if you don't go with the lowest quote, we're going to want to see a determination of why you didn't. So make sure that you document all that and keep that in your files for us to look at. For even smaller purchases where the price is less than $50,000, the purchasing agent should follow the written policies of the purchasing agency or rules adopted by the governing body. So those are your local rules that I mentioned, having those written policies a little earlier. And they can include whatever you determine locally of how you're going to handle small purchases like that. They can include, but they don't have to, provisions for obtaining quotes or even bids. So we've seen some that will say if it's less than $50,000, we're going to take 2 quotes. or we are going to accept bids even though we don't statutorily have to, or we're going to take 10 quotes. It's whatever you decide locally, and that it's in the policy that is adopted, and that's what we're going to audit to, is whatever your local rules call for. If you don't currently have a local written policy for small purchases, we'd recommend approaching your council about adopting one, and you might point out to them Indiana Code 52233 that I mentioned earlier that requires written policies. I mentioned special purchasing methods earlier. Indiana Code 5-22-10-1 states an agent can make purchases under this chapter without bids for special methods or conditions, such as if there exists under emergency conditions a threat to public health, welfare, or safety, the existence of a unique opportunity to obtain supplies at a substantial savings to a governmental body, some data processing contracts, or when the compatibility of the equipment is a substantial consideration. If there were no offers received under other purchasing methods, when the market structure is based on price, but the government is able to receive a discount to the established price, and if there is only one single source for the supply. Those are the main ones. So you want to look at all of 522.10.1 to see what the others, but those are the ones I think we've experienced the most and seeing. If you use a special purchasing method, you'll want to be aware of 522.10.3, which provides for what the documentation is that you need to have. It says the purchasing agent will need to keep contract records in separate files. The contract file must include the determination for the basis of the special purchase and the basis for the contractor that's selected. So this could include, and we probably recommend it include, the written opinion of your attorney as to why a particular special purchasing method applied, and why you went that way. And finally, that statute requires that the records must be maintained for a minimum of 5 years, and definitely not until we've audited them. And it should contain the names of the contractors, the amount, the type of the contract, and a description of what was purchased. And it'll be those separate files that we're going to look at if during an audit, if you purchase something using a special purchasing method. So that's what we had to cover regarding public purchase. Next, once you've obtained equipment and materials, at some point they may become obsolete, or you may need to dispose of them. So I'll turn it back over to Susan and she'll cover that next.
Okay, so we're going to switch gears now onto the disposal of personal property. This is not nearly as involved as real property, but there's still a lot of exceptions. There's 23 to be exact, and those are all listed in section 1 of the statute. But we're just going to go over the basic requirements of that today. Again, what we want to do here is to let you know what's needed for audit, and to give you a general idea of the rules related to the disposal of personal property. And I have references for the exceptions that are listed in the statute, those 23 exceptions, and then there are definitions listed in 522.2 as well, so you would want to take a look at those. The disposing agency, when it talks about a disposing agency, would be council, and when they talk about a disposing agent, it would be an individual authorized by council to act on their behalf. A purchasing agent can sell personal property that's been left in the custody of that unit, or has remained unclaimed for more than a year, or it belongs to the governmental body but it's no longer needed, or it's unfit for the purpose for which it was intended. In general, if you have one item with an estimated value that's greater than $1,000, or more than one item with an estimated value of greater than $5,000, you have 3 options. One is use of an auctioneer, the next would be an internet sale, and then there would be a public sale or sealed bids. All of these require a notice of sale, and those notice requirements are there. If you'll notice here, there's a notice in 522-2211 that refers to 531. The one in 522-2211 says that the publication shall be made at least 15 days before the date of sale. But if you go to 531, it says that it has to be published 2 times at least 1 week apart, with the second publication made at least 7 days before the date of the bids will be received. So those two don't exactly agree, but they can work together. So you might want to talk to your attorney about those public notices and how you can actually fulfill both of those. Now, the notice that's required in 522-2211 is in addition to any notice that would be given by an auctioneer or an internet auction site. But again, please always discuss that with your attorney. Now, to use an auctioneer, that auctioneer does have to be licensed, and the advertising that's done by the auctioneer does need to include a detailed description of the property that's to be sold. Again, the gross proceeds received by you may be used to pay the auctioneer, but the preferred method or the correct method is to go ahead and receive those gross proceeds into your fund, and then you can pay the auctioneer out of that through the normal claims process. And that auctioneer's fee does have priority over other expenses and liens. There's also provision again for the internet sale. The site does have to be approved by the Indiana Office of Technology, and that site is there for you. You can go to that site and look up the list of internet sale sites that have been approved. The notice does have to include a detailed description of the property to be sold. And then you can pay the cost there for conducting the auction as it is required by the person maintaining that auction site. So in an audit, we would be looking for some kind of written documentation that how payment was to be made. And you, of course, want controls over that. You can also conduct a public sale or receive sealed bids. That does have to be advertised in accordance with 531, and your sale would be to the highest bidder. Now, there are times when you can dispose of personal property by private sale without advertising, and that is when there's one item with an estimated value of less than $1,000, or if you have more than one item, then the estimated total value of those items is less than $5,000. So make sure, again, for audit purposes, that those values are, those estimates are documented. There are special situations that are specifically discussed in the statute. Those are listed here on this slide, and we're going to go through each one of them. It's just kind of a title slide. So for recyclable property in 522-22-7, that can be sold at a public or private sale, or it can be transferred without advertising. Worthless property, if the value of the property is less than the estimated cost of the sale and transportation of that property, then that can be demolished or junked. And again, some documentation should exist to show that the property is worthless by that definition. Law enforcement vehicles have some special provisions in the statute, especially in regard to repainting them if they're going to be used on a public highway. There is a requirement that you have to provide a copy of Indiana Code 522-22-9 to the purchaser, which explains all of the requirements for repainting. The repainting is not required if it's transferred to another governmental entity. Now, as far as exchange with a governmental body, personal property can be exchanged with another governmental body upon terms and conditions that are agreed to by them, and the adoption of substantially identical resolutions by each governmental unit. The transfer again can be made for any amount of property or cash that's agreed upon by the governmental bodies. But as I said earlier, something does need to be exchanged there, even if it's nominal. There are provisions for transfers to a fire department. So fire trucks, emergency service vehicles, firefighting or emergency services equipment that's for use in providing fire protection or emergency services. That's all subject to this statute. It can be transferred to a volunteer fire department or a fire protection district or fire protection territory by sale, gift, or other type of arrangement. There is a provision in this particular section where the fire department, a fire department in your county has the first right of refusal. And if nobody in your county wants it, then you can open it up to any fire department in Indiana. So on the disposal of personal, I guess I had something out of order here. Okay, so we have some resources available on our website for you. If you go to the cities or the towns page and you go under the section called Indiana Codes and click on that triangle, you'll see a whole list of subjects there that will have the statutes and a general explanation, and then the general rules and the more specific rules and exceptions. So you'll see we have illustrated here that the public purchasing law is there, and the purchase of land or structures is also there. There's also a section for the disposal of property. So you'll want to take a look at that. It is a good resource, but again, we always recommend that you look directly to the statute when making decisions. These are just kind of to guide you and provide some assistance that way. The other thing that you can do to look at the statutes is you can go to the Indiana General Assembly webpage, which is at iga.in.gov, and then you can enter the statute in those boxes there. So you could enter 36-1-11 and hit the search button, and it would go there for you. So that is also a good resource for you. I thought I had a summary slide in there, but I might have missed it. But just to kind of recap what we need for in an audit, you will want to document and keep in your audit files the estimated value of personal property that's to be disposed of. Document any special provisions for the transfer of sale without advertising, so you'll want to make sure all of that is documented. You'll want to maintain ordinances and resolutions related to exchanges. And then when you record any personal property disposal, if that personal property has met the threshold and it's been recorded on your capital asset ledger, then you're going to want to show that as a reduction when you dispose of it in the amount of the historical cost. So thank you very much for that. I think that we're done with the information on the real and personal property disposal. I think Todd's going to go over some information on how to subscribe to our email list, and then we'll open it up for questions and answers after that, and we'll go through all of the questions that have been asked or will be asked. Thank you.
Okay, well, we are cautiously excited about this next thing just because it is brand new and it allows you to subscribe to receive emails, mass emails from the Board of Accounts. We have maintained a list or attempted to maintain a list in the past, so when we send out bulletins or memos, we know we're giving it to the majority of cities and towns, but maybe not everybody, and especially this year, we've got new clerk treasurers who took office the first of the year, and some that have taken office since then. So this is going to be a way, we hope, that you can go in and register and subscribe and be able to get on our list, so when we send something out, you should receive it. And once, at least I learned how to use it a little better. Yesterday I sent out 2 to cities and towns, so I apologize for that. The second one, you probably noticed, was addressed to libraries, and I forgot to go back in and change my audience when we're sending those out, and I sent it I think a couple of times. So hopefully in the future I will learn and not make that mistake and fill your inboxes with emails that don't pertain to you. But if you can go to our website, our homepage, like you see on the screen, if you scroll down a little bit, there is a sentence right here that says to subscribe to our email lists, please sign up on this page. I'm going to suggest that our IT people make that a little larger because it was kind of buried on there. I missed it the first time when they said it was on our homepage and they had to rub my nose in it to see it. But if you click on this link, it will take you to this page that says SBOA Communications Sign Up. Now, when I tried to do it yesterday using Google Chrome as my my internet, I didn't see all of these. So where it says first name, last name, and I'm going to scroll down, that was all blank. So right now I'm using Firefox, and it shows in Firefox. And I didn't try it in Internet Explorer or whatever Microsoft calls that now. So if you don't see this on your browser, if you don't see it come up, try a different browser. But there should be a place for you to type in your name, first name, last name, indicate your county, the name of the governmental unit that you're with, what your position is, and then the all-important email address that you want these to go to. And then you can select from a list of different entities that we send emails and notices out to. So click the ones that you want. If you want to click them all, you're going to get all kind of emails and that aren't going to pertain to you. But if you're a clerk treasurer, you want to know what's going on in your county highway, you can put a check in that box. But most of you are going to put either in for cities or towns, or if you have a court, there's a list just for those courts. And then you'll need to check the box that you consent to our privacy, and then just follow the rest of the instructions. The one thing we want to maybe warn you about is, as of today, it's our understanding that if you ever unsubscribe to this, it will unsubscribe you to any emails that you get from other agencies as well. So if like you signed up for, or you subscribe to DLGF's emails, if you unsubscribe to ours at least, it will take you off of the DLGF list as well. The state is using one, it's through an internet site, it's one provider that is managing all of this for us, and like I said, as we understand, if you unsubscribe from one, it takes you off of all of them for some reason. So just be careful if you unsubscribe from ours, but you still want to get DLGFs, you might be missing those because it's going to take you off of all of them for now. Susan mentioned earlier that the training, the fall district meeting that's coming up at the end of October, we're going to be sending a call letter out, and I hope to do that later today or tomorrow. We'll be using this feature, so that'll give you some time if you're not signed up, go ahead and get on that list. So if you got something from us yesterday on the COVID appropriations and accounting for that, you are on the list. I forgot to ask, I was going to ask Chase, and maybe you know this question. If you're already on the list and you sign up again, I don't think that's an issue. I think it'll just override what's ever on there to begin with. But if you're not on there currently, you'll want to go ahead and get subscribed. And that can be to anybody in your office. So if you've got a deputy or a utility person that wants to get these notices, they can sign up there too. Your mayors, your councils, they can sign up and get those emailed as well. So I think that is it, and we should be ready for questions.